Hello and welcome. Karen Reed's defense team submitted a new motion today. It's the motion for reconsideration of the March 6th order that Judge Beverly Cannoni made. Today is March 13, 2025. Let's get into the motion. And if there's time, I will also read Robert Alessi's affidavit, which is accompanying the motion. And the motion for reconsideration begins. It's the defendant's motion for reconsideration of March 6, 2025 court order denying defendant's motion to exclude the testimony of the Commonwealth's witness, James W. Crosby, PhD. Now comes the defendant, Karen Reed, Miss Reed, or defendant, and respectfully requests that this court reconsider its March 6, 2025 court order, March 6 order, denying defendant's motion to exclude the testimony of the Commonwealth's witness, James W. Crosby, PhD, Dr. Crosby. And after such reconsideration, defendant requests that the court exclude the entirety of the proffered testimony of Dr. Crosby. In the alternative, and at a minimum, defendant requests an evidentiary hearing to determine whether the Commonwealth can meet its burden to satisfy the requirements of Daubert-Lanigan as regards Dr. Crosby. The defense could complete its questioning of Dr. Crosby in approximately 1/2 day of any hearing. So far, guys, as a summary of what the defense is asking for in the first paragraph, they are asking Judge Beverly Cannoni to reconsider her denial of excluding Dr. Crosby. The defense team submitted a motion to exclude Dr. Crosby because the defense does not believe he meets the criteria of an expert witness to testify about the wounds to John O'Keefe's arm. Also, Dr. Crosby is not an MD, and per Massachusetts regulations, per the rules, Dr. Crosby is not supposed to comment at all about John O'Keefe's wounds because Dr. Crosby is not an MD. Remember, Judge Beverly Cannoni made an issue about one of the ARCA experts testifying about John O'Keefe's wounds because that ARCA expert was not an MD, right? So guys, again, Dr. Crosby is also not an MD, but he is trying to testify about John O'Keefe's wounds and the dog bite marks and claw marks on John O'Keefe's arm. And so the defense filed that motion to exclude Dr. Crosby's testimony. Judge Bev denied it on March 6th. And within the first paragraph of the motion for reconsideration, the defense is asking Judge Bev to reconsider her denial, to look at what they presented, to look at the evidence, and to reanalyze everything and exclude him entirely, and to exclude his testimony as well, the testimony he provided. Thus far, the defense wants him out entirely, and I agree with them. And then they're also asking that as an alternative and as a minimum, that even if she denies again the defense's motion to exclude Dr. Crosby, the defense is saying at a minimum, give us a Daubert hearing so that we can question Dr. Crosby and we can determine if he really meets the criteria under Daubert-Lanigan. So those are the two things that they're asking for so far in the first paragraph. Let's keep reading. And they're also saying that they can get it done within 1/2 day of any hearing. You know how Judge Bev's always worried about the time. How long is it going to take you? How long is it going to take, right? It's like, yeah, she's a busy judge, but again, she's not supposed to be a judge. You're not supposed to be that corrupt and be a judge for the superior court, you know? Again, she could have recused herself, but she didn't want to. This is her case, but she's always impatient when it comes to the defense. So it's like the defense is forced to tell her, look, it's only going to take us a 1/2 day of any hearing, you know? Anyway, continuing. The court's March 6 order. In denying defendant's motion to exclude the proffered testimony of Dr. Crosby, the court stated in its March 6 order that, quote, the Commonwealth has satisfied the foundational requirements of Daubert-Lanigan. The evidence will assist the jury. Dr. Crosby is an expert in dog bite wounds. There is an appropriate basis for his opinion in the record, and the proposed testimony principles and methods are reliable, the defendant's objection goes to the weight of the evidence, not its admissibility. And those were Judge Bev's words, guys. And Judge Bev actually made a similar statement when she allowed Dr. Marie Russell to testify for the retrial. Judge Bev argued that the prosecution was arguing over the evidence and that it was up to the jury to determine the evidence, which was actually a correct decision on her part for once. But uh, she's giving the defense the same argument she gave the prosecution. If you guys notice, the defendant's objection goes to the weight of the evidence, not its admissibility. What I completely disagree with her though. Like it goes directly to its admissibility if the dude isn't even an MD, you know? Anyway, continuing with the motion. The court did not provide any record citation or other record evidence for how the Commonwealth had met its burden to satisfy the 5 foundational requirements, including prominently the, quote, methods are reliable, end quote, requirement. See Commonwealth versus Polk. It's a 2012 case law citation. Continuing, nor did the court address the alternative request of the defendant that a Daubert hearing be held should the court not exclude Dr. Crosby outright on the papers alone. So, to summarize paragraph 2, the defense is saying, Judge Bev, you didn't give us a reason. You didn't give us a reason for denying our request to exclude Dr. Crosby. You didn't go into details. You didn't go into any specifics. You didn't cite any portion of the evidence or any portion of our argument to back up your decision. You provided zero reasoning, right? And then they're also saying that, let's see, forgot already. They're also saying that Judge Bev didn't even consider at all their request for a Daubert-Lanigan hearing to begin with, because when the defense filed the motion to exclude Dr. Crosby, they also asked for a Daubert hearing, and Judge Bev didn't even address their request for a Daubert hearing. She like ignored it. She's like, I'm denying your request to exclude Dr. Crosby. And she like ignored the request for a Daubert hearing altogether. Let's see if she ignores it again this time, guys. Okay, let's get back to the motion. All right, and the third paragraph, sorry. The March 6 order contrasts with the court-ordered 2-day evidentiary hearing of Dr. Marie Russell, a medical doctor with approximately 30 years experience as an emergency medicine physician and forensic pathologist. Dr. Russell co-authored peer-reviewed books on dog-inflicted wounds on humans and submitted an 11-page report before the hearing in which she documented her pattern recognition methodology with robust citations to peer-reviewed studies and articles that appeared in 27 footnotes throughout her report. Excellent, guys. You see the contrast between Dr. Marie Russell and Dr. Crosby? I argued this in a previous video just a couple days ago. I was like, how could Hank Brennan give Dr. Marie Russell so much crap? How could he ever say that she wasn't qualified enough when you consider Dr. Crosby's qualifications, the lack thereof? Again, it was a total show. Hank Brennan fighting to exclude Dr. Marie Russell was a total show. You know, he was just so full of shit. Like, he's so frustrating. Okay. Yeah. Because again, guys, as I argued, if if Dr. Marie Russell is that much more qualified than Dr. Crosby, and Hank Brennan is okay with Dr. Crosby, what the hell was Hank Brennan fighting for? Why was he fighting so hard to exclude Dr. Marie Russell when his own alleged dog bite expert is nowhere near as qualified as Dr. Marie Russell? That's Hank Brennan logic for you guys. Continuing, the instant motion for reconsideration. The defendant does not waive any and reserves all of the bases for exclusion of Dr. Crosby as stated in her original exclusion motion. Yet for efficiency, in this reconsideration motion, the defendant focuses on just factor 4 set forth in Polk, the case law, namely, quote, that the theory underlying the opinion is reliable, end quote. This factor is also known as the Daubert-Lanigan parlance as the methodology prong. A failure of any one of the 5 foundational factors set forth in Polk compels exclusion of the proffered testimony at issue. Excellent wording by the defense. Continuing. The Commonwealth's opposition to the defendant's exclusion motion. The Commonwealth had 4 opportunities to show that it can meet the Daubert-Lanigan methodology prong. Its written opposition dated February 17, 2025. The supplemental report of Dr. Crosby, sorry, I went too far. Dr. Crosby dated February 19, 2025, in which he discussed the mold aspect of his unsupported mold measurement methodology, but failed to account for the absence of any requisite overlay in his methodology, oral argument on the exclusion motion on March 4, 2025, and the list of cases in which Dr. Crosby has testified in court, which was submitted to the court on March 6, 2025. In each of the opportunities, the Commonwealth failed to even attempt to show that the purported mold measurement methodology employed by Dr. Crosby in opining on whether the wounds to the right arm of the decedent were caused by a dog bite or dog attack is generally accepted in the relevant medical or scientific community, or that his methodology meets the appointed Daubert-Lanigan factors. Excellent from the defense. And just to briefly summarize that, they're essentially saying the Commonwealth failed to prove that Dr. Crosby is in fact an expert, and they failed to provide examples like and the mold measurement itself, which again, like, no, not me, like nobody believes that they actually measured Chloe's teeth marks, like her nobody believes that the Commonwealth obtained a mold of Chloe's teeth, period. I'm not buying it, and no one else I know who knows what's going on in this case is buying it. There is no way the Commonwealth has a mold of Chloe's teeth. No effing way. The fact that they want to say that just goes further into this widely accepted belief that it's a cover-up. This widely acknowledged understanding that it's a cover-up. Continuing, notably, Dr. Crosby has never attempted to make such a showing either. His report is completely bereft of even a mention of satisfaction of general acceptance of his mold measurement methodology or satisfaction of the Daubert-Lanigan factors, let alone a showing of meeting them. And he has never submitted an affidavit to support anything about himself, including his qualifications or documentation of any kind of how his purported methodology is generally accepted or otherwise reliable, with citations to medical or scientific literature. You guys see that? Like, if you're going to present yourself as an expert, at bare minimum, you need to submit an affidavit. An affidavit is a sworn statement to the court. And it's like, look, court, look, judge, like, I am under the perjury standard here. This is my affidavit. And if I lie in my affidavit, I am committing perjury. You know, it's one of the reasons why you want an affidavit. Is to say, like, I affirm this. I swear to the court. I swear to God that this is the truth. And the defense is saying that Dr. Crosby didn't submit anything like that. You guys remember Dr. Marie Russell submitted numerous affidavits. Dr. Richard Green, the cell phone extraction expert, the cell phone data expert, forensic computer expert. He submitted multiple affidavits. The the ARCA experts submitted affidavits. Like every expert on the defense's side submitted affidavits. It's what you do when you're an expert and you're showing your sincerity, you're showing your credentials, you're giving a list of your experience and how it meets the industry standards. You're not just some random dude from the street, right? And Crosby could be some random dude from the street for all we know. He submitted no affidavits, no sworn statements, as if he's avoiding being charged with perjury because he didn't swear anything under oath yet. It just okay, it's more shady shit from the Commonwealth. Continuing. And I really like this part, like, or otherwise reliable with citations to medical or scientific literature. Like, the dude provided nothing. And again, guys, for Dr. Marie Russell to have gone above and beyond, for the defense team to have gone above and beyond to prove that Dr. Marie Russell is an expert, and for her to make multiple references, for her to be so credentialed and experienced, and to be so passionate about her career, about the field she's in, and for Hank Brennan to have such an issue with her as if she was some random person from the street. But but Hank Brennan is okay with Crosby, the no affidavit Crosby. Continuing, the February 17, 2025 affidavit submitted by Mr. Brennan is likewise of no weight in the inquiry, as he lacks first-hand knowledge or the requisite expertise in the subject matter of the dispute. But even in his affidavit, Mr. Brennan mentions nothing about satisfaction of the common acceptance precept or the Daubert-Lanigan factors. Tellingly, good word, defense team. Tellingly, Mr. Brennan merely states in paragraph 7 in a bald conclusion that Dr. Crosby has, quote, engaged in substantial methodology, end quote. Guys, remember Hank Brennan going all up and down about the methodology? Remember? I'm pretty sure there were memes made. Like, he, first of all, he like emotionally abused Dr. Marie Russell. She didn't deserve any of Hank Brennan's treatment. She's such a kind, genuine, sincere woman, who loves her job, who knows her shit. And Hank Brennan is such a jerk as a prosecutor to treat her like she was garbage. And for him to like stress up and down about the methodology. And yet he has the audacity, the gall to be like, yeah, Crosby's got a methodology. But he doesn't go into it. Oh, he doesn't go into it. You know, Hank Brennan, I fucking swear. Continuing. Okay, substantial does not begin to satisfy the requirement that the mold measurement methodology of Dr. Crosby is supported by evidence of common acceptance in the relevant medical or scientific community or satisfaction of the relevant Daubert-Lanigan factors. Well worded by the defense team. Uh, I love that, guys. Tellingly. So tellingly. Yeah, Hank Brennan deserved that for sure. Continuing, likewise, in its written opposition, the Commonwealth stated that Dr. Crosby, quote, engaged in recognized methodology to study the abrasions on John O'Keefe's arm, but wholly failed to state any source for such recognition. And there is none. There is none. Simple, succinct sentence. I'm going to read it again. Likewise, in its written opposition, the Commonwealth stated that Dr. Crosby, quote, engaged in recognized methodology to study the abrasions on John O'Keefe's arm, but wholly failed to state any source for such recognition. There is none. There, as in, there are no sources for such recognition. Again, guys, Dr. Marie Russell had to be so specific. She had to be so literal because Hank Brennan kept alleging that she didn't have what it takes. She didn't have the credentials. She wasn't a real expert. She provided more than enough to prove to the world that she's an expert. But the Commonwealth is allowed to be as vague as hell, as vague as they want to be. And they're allowed to keep referring to the dog bite marks and claw marks on John O'Keefe's arm. They're allowed to keep referring to those marks as abrasions when they are not abrasions. I've said it before, guys. The reason the Commonwealth continues to use the word abrasion referring to John O'Keefe's wounds on his right arm is because the word abrasion better aligns with the Commonwealth's narrative that an SUV backed into John O'Keefe. That's why the Commonwealth refuses to refer to those marks on John O'Keefe's arm as dog bite and claw marks. They refuse. Continuing, as a result, the Commonwealth has provided the court with no basis on which to conclude that the mold measurement methodology of Dr. Crosby is reliable, the prerequisite for satisfying the fourth factor of Polk, the methodology prong of Daubert-Lanigan. The court cannot satisfy its gatekeeper function by invoking the same conclusory statements as the Commonwealth has invoked here regarding a reliable methodology. Holy hell. Guys, the defense team is not messing around. They're not messing around. Okay, that last sentence is powerful. Brilliant. The court cannot satisfy its gatekeeper function by invoking the same conclusory statements as the Commonwealth has invoked here regarding reliable methodology. Like, all Judge Bev did was repeat what the prosecution said, but as the gatekeeper, she's not supposed to just repeat what they said. She's supposed to be the gatekeeper. She's supposed to be discerning. She's supposed to provide reasoning. Awesome, solid argument from the defense. And they're calling her on it. And she's going to get pissed. She's going to get more pissed, guys, because she doesn't like being called out. She's got too much of an ego, and she's spent too many years in power, corrupt power, to take any accountability for her fuck-ups. Continuing, the gatekeeping function of the court under Rule 702 and its importance. Case law makes clear that the gatekeeping function of the trial court is especially significant. This is all the more so in light of the seriousness of the charges lodged by the Commonwealth here. As Massachusetts Guide to Evidence 2024 states, the Massachusetts Rule 702 is based on Federal Rules of Evidence, FRE, Section 702, while additionally maintaining the, quote, common acceptance test, see Massachusetts Guide of Evidence, subsection 702. As a result, federal decisions interpreting Federal Rules of Evidence 702 are particularly instructive. Commonwealth versus Lanigan. The gatekeeping function of the trial court under Daubert-Lanigan and Rule 702 precepts is of paramount importance. Commonwealth versus DeChico. And in quotations, under Daubert-Lanigan, the motion judge in her role as gatekeeper, they have this in bold print, guys, has a significant function to carry out in deciding on the admissibility of a scientific expert's opinion, end quote. Boom. You guys see that? So all the way up here in Judge Bev's decision that the defense is citing, she's like, the Commonwealth has satisfied the foundational requirements of Daubert-Lanigan. The evidence will assist the jury. Dr. Crosby is an expert in dog bite wounds. There is an appropriate basis for his opinion in the record, and the proposed testimony principles and methods are reliable. The defense's objection goes to the weight of the evidence, not its admissibility. Right? That was Judge Bev's statement. The weight of the evidence, not its admissibility. And what the defense is citing is actually federal case law and state law, which Massachusetts has adapted. But it's powerful. It's powerful. So in response to her statement, the defense is saying under Daubert Lanigan, the motion judge in her role as gatekeeper has a significant function to carry out in deciding on the admissibility of a scientific expert's opinion. So Judge Bev can't just be lazy about this. She can't just copy and paste what the Commonwealth, what the prosecution said. It's actually her role. She actually has to work here as a judge. She has to work. She can't just sit on her ass. You know, she is the gatekeeper, and she has a significant function to carry out in deciding on the admissibility of a scientific expert's opinion. Great job, defense team. Continuing, the reason for this importance was recently underscored as follows. Because Rule 702 grants experts wide latitude to offer opinions, including those that are not based on firsthand knowledge or observation, expert evidence can be both powerful and quite misleading. Daubert versus Merrill Dow, Pharmaceuticals. Citations and internal quotation marks omitted. As such, this is also in bold, guys, bold print. As such, the importance of the gatekeeping function cannot be overstated. Excellent. I just want to read this last part, guys. Because Rule 702 Rule 702 grants experts wide latitude to offer opinions, including those that are not based on firsthand knowledge or observation. Expert evidence can be both powerful and quite misleading. You guys see that? That's why it's Judge Bev's job to be the gatekeeper. It can be powerful and misleading, and it's her job to make sure it's not misleading. Bare minimum. Good job, defense team. And they cite the case law United States versus Barton. And another one, Sardis versus Overhead Door Corporation, Commonwealth versus Rentala, Commonwealth versus Hines, Commonwealth versus Patterson, Commonwealth versus Britt, in quotations, a judge's findings must apply the correct legal standard to the facts of the case and must be supported by an examination of the record. Excellent. And did she do that, guys? Like, her findings must apply to the correct legal standard to the facts of the case and must be supported by an examination of the record. And remember, guys, Judge Bev provided no citation of the record. She provided no citation of what occurred in the defense's arguments and in the prosecution's rebuttal. She cited nothing to back up her reasons. And here's the defense team citing case law in which she is supposed to. Case law telling all of us that she is supposed to provide reasoning. She can't just generally say, I deny this. It meets the standard. And he's an expert. And in my opinion, you're obsessing over the weight of the evidence, not the admissibility. But why? How, Judge Bev? Why do you say that? What are your reasons? She provided no reasons. Continuing. The gatekeeping inquiry must be tied to the particular facts. Exactly. You see that, guys? The gatekeeping inquiry must be tied to the particular facts. Her decision to deny the defense's motion to exclude Dr. Crosby is supposed to have reasoning behind it. She's supposed to provide reasoning. It must be tied to the particular facts, and she provided none. It continues, the Polk-Daubert-Lanigan analysis is no different, whereas here the witness in question is stipulated to be a rebuttal witness. And in parentheses, contemplating no different standard for rebuttal evidence. So what the defense is saying, that even if Dr. Crosby is only going to be a rebuttal witness, he is still held to the same standard. Contemplating no different standard for rebuttal evidence, even if he's only going to be a rebuttal witness, a rebuttal expert for the Commonwealth, for the prosecution, he still has to meet the same standards as any other witness. Continuing, the facts and law in Hilsinger Co. versus Clean Concepts are quite similar to the instant case and thus compel the same result. In Clean Concepts, the court stated as follows in response to a defendant's proffer of an expert witness. The, quote, defendant has not directed the court to any evidence demonstrating that Sower's methods for determining primary purchasing consideration have been tested, subjected to peer review, are commonly accepted in the field, or have otherwise been scientifically validated. Nor has defendant made any attempt to demonstrate that Sower's methods are reliable independently of industry practices. Instead, it simply concluded without any citation, support, or further argument that Sower's worked from a reliable survey methodology. That assertion alone, standing alone, is not sufficient to demonstrate the reliability of Sower's methods. Excellent case law citation from the defense. And the defense is saying this applies, and because it applies so much to what the defense is arguing, the defense is owed the same conclusion, meaning that Judge Bev is supposed to discern, she's supposed to decide that it's not enough. His credentials are not enough. It's not sufficient to demonstrate the reliability of Dr. Crosby's testimony. You can't just give general statements. You have to provide examples. The prosecution is providing general statements, and so too is Judge Bev providing general statements. Continuing, the Commonwealth has postured its opposition to defendant's motion to exclude Dr. Crosby almost exactly as the defendant did in Clean Concepts. Substitute the conclusory recognized methodology in the instant case with the reliable survey methodology parlance in Clean Concepts. Like in Clean Concepts, the conclusory and unsupported, quote, recognized methodology, end quote, assertion of the Commonwealth here is insufficient. Moreover, Dr. Crosby does not even assert that his methodology is recognized, let alone does he cite to the literature or otherwise for medical or scientific acceptance of his methodology. And this silence exists in the high-pitched volume of medical and legal literature calling into serious question the reliability of even known methodologies involving forensic odontologists, veterinarians, medical doctors, medical examiners, all of which are lacking here with Dr. Crosby's solid, guys. Such a solid paragraph. I would love to keep rereading things that are great, but I don't want to take up more time than necessary. As always, the link to this motion will be in the description below. Continuing, likewise, the March 6th order does not state any evidence of how or where the purported recognized methodology of Dr. Crosby is generally accepted in the relevant medical or scientific community, nor does the March 6th order analyze any of the 5 Daubert-Lanigan factors by tying them to the facts of this case or otherwise cite support in the record of the motion, or how the unsupported mold measurement methodology of Dr. Crosby is reliable. I love that part especially. Or mold measurement methodology of Dr. Crosby is reliable. They don't even go into how the alleged mold of Chloe's teeth is reliable. I bet they don't have a chain of custody for that either, guys. I am so sure they don't even have a chain of custody for how they obtained the molds of Chloe's teeth. Defendant respectfully submits that had the court performed the entirety of the gatekeeping function with reference to the motion record evidence, it would have had to have come to the inexorable conclusion that the mold measurement methodology employed by Dr. Crosby in coming to his opinions about the medical cause of the wounds to the right arm of the decedent was completely unsupported and thus not reliable. Good job, defense team. The Commonwealth has had 4 chances to tether the methodology proffered by Dr. Crosby to a study or other form of common acceptance or otherwise satisfy the appointed Daubert-Lanigan factors, yet it has failed to do so each time. This failure is not an oversight or mere happenstance. Rather, it is because the methodology of Dr. Crosby is not generally accepted in the relevant medical or scientific community and cannot satisfy the Daubert-Lanigan factors. Excellent, guys. Such a thorough, concise motion from the defense. Continuing. Conclusion. Under Daubert-Lanigan and Commonwealth versus Polk, respectfully, the court is duty-bound to fully exercise its important gatekeeper function by examining the record and making what can only be one finding: the failure of a reliable methodology by, and thus, the exclusion of Dr. Crosby on the papers alone. Any testimony by Dr. Crosby at trial about his unsupported mold measurement methodology would seriously mislead the jury into believing his methodology is based in science and is reliable. Nothing could be further from the truth. I will read that sentence again, guys. Beautiful. Any testimony by Dr. Crosby at trial about his unsupported mold measurement methodology would seriously mislead the jury into believing his methodology is based in science and is reliable. Nothing could be further from the truth. Mic drop. Mic drop for the defense. Continuing, and because the issue of how the injuries to the right arm of the decedent is a key issue for both parties, his testimony with the sponsoring imprimatur of the Commonwealth, would be extremely prejudicial to the defendant. In the alternative, and at a minimum, an evidentiary hearing on Dr. Crosby is compelled. Beautiful, guys. Oh, following the Karen Read case isn't just about like uncovering government corruption and police corruption, law enforcement corruption. It's also an example of what a badass defense team is like. That's also what's so amazing about the Karen Read case. Like, if you want to learn about a really solid defense team, if you want to know what badass attorneys look like, what they write, what they argue, you gotta read the defense's motions in the Karen Read case. That they just consistently put forward solid motions over and over again. Like, and they're always kicking the prosecution's ass. Whether the prosecution wants to admit it or not, they are always kicking their ass. Okay. Respectfully submitted for the defendant, Karen Read, by her attorneys, Robert J. Alessi, badass Robert, and Alan Jackson, badass Alan, Elizabeth Little, badass Elizabeth, David R. Unetti, badass David Unetti, and it's dated March 12th, but again, it was submitted today, March 13. Now, let's read the affidavit that accompanies this motion for reconsideration. This one's in white, and it reads, Affidavit of Robert J. Alessi. Sorry, let me share the tab. Okay, sorry about that. It reads, Affidavit of Robert J. Alessi in support of defendant's motion for reconsideration of March 6, 2025, court order denying defendant's motion to exclude the testimony of the Commonwealth's witness, James W. Crosby. I, Robert J. Alessi, hereby state as follows. I am a partner with the law firm of DLA Piper LLP, and I am a member in good standing of the Bar of the State of New York. I am co-counsel for Ms. Reed and have been admitted pro hac vice in the above captioned matter. I make the following statements based upon my personal knowledge in support of the defendant's motion for reconsideration of March 6, 2025 court order denying defendant's motion to exclude the testimony of the Commonwealth's witness, James W. Crosby. Number two, in denying the defendant's motion to exclude the testimony of Dr. Crosby, the court stated in its March 6 order that the Commonwealth has satisfied the foundational requirements of Doppert-Lanigan. The evidence will assist the jury. Dr. Crosby is an expert in dog bite wounds. There is an appropriate basis for his opinion in the record, and the proposed testimony, principles, and methods are reliable. The defendant's objection goes to the weight of the evidence, not its admissibility. And we read that in the motion. And I'm going to zoom into this one. So the affidavit's just 2 pages. We're on the second page. Number 3, because the Commonwealth has not shown and cannot show that the mold measurement methodology of Dr. Crosby is generally accepted in the relevant medical or scientific community and cannot satisfy the 5 foundational factors identified in Commonwealth versus Polk or Doppert-Lanigan factors, and for the other reasons discussed in the accompanying motion for reconsideration of the March 6 order, defendant respectfully requests that the court reconsider its March 6 order and exclude the testimony of Dr. Crosby. Number 4, in the alternative, the defendant requests that the court convene a Doppert-Lanigan evidentiary hearing on Dr. Crosby. Defendant reserves all and does not waive any arguments or rights about the other failures of the Commonwealth to meet its burden of proof regarding Dr. Crosby, such as the lack of the requisite qualifications of Dr. Crosby, signed under pains and penalty of perjury, this 12th day of March 2025, Robert J. Alessi. So you see, guys, this is an affidavit, as I was saying. And if you're trying to show sincerity and integrity with the court, you submit an affidavit. And all affidavits are signed under the pains and penalties of perjury, right? Like, because there needs to be accountability when you bullshit the court. There needs to be accountability whenever you bullshit the court. Just saying, like, and again, Dr. Crosby did not submit one affidavit. Is he trying to avoid being charged with perjury because he hasn't yet sworn in? He hasn't yet affirmed anything with a sworn statement? Like, is he trying not to be charged with perjury here? You know, it's just more fishy shit from the prosecution, you know, and I don't know where they're getting all these so-called experts, people who are like willing to lie for them, people who are willing to half-ass their job as an expert. Like, I don't know where they're getting them from. You know, like, just, it's like the prosecution has like people with no integrity in their back pocket. Like, whenever they need to cover something up, it's like they're used to this. This is their MO. You know, like, we can get anybody to come on that stand and lie for us or half-ass some testimony for us on our behalf. Just crazy shit, guys. Anyway, those were the 2 motions for today. I was going to share an article with you guys, but I think I'll save that for another time. Again, as always, I will leave the link in the description below. Thank you all for watching.